My senior argued the matter with me once. Therefrom, you have to give an again the Pakal. And next to be removed. AP is not. Are you the remembrance? This matter was posted on 26/3 launch. How it
26/3?
came today?
No, thereafter this court, you only sought for early date. That's why
Yes,
this
we
sought. Yes,
we sought early date.
yes, early date. That's why posted.
We are
today.
for criminal MP.
Yes. Court post on next month, 26/3. Thereafter, you have not seen the diary. Not even seen the diary on the date of adjournment. Yes. Because you sought for early date, thereafter this court feels that it is appropriate to post.
I am the petitioner in the state order.
He is for criminal OP. I am for criminal MP.
I think 3 petitions filed.
Yes,
Yes.
Mr. Anand already argued the matter.
yes,
So 2 advocates are for, sorry, 100.
Not submitted arguments.
The matter.
yes,
This court on that date, not in a position to hear.
yes.
That's why posted some other date. Yes.
Now the Mr. Anand, my elder brother, has
Given a change of.
change of Akalat.
Yes. So you can circulate the
Yes,
memo.
Already circulated. Already circulated.
Also.
Yes.
Our name still we present on the.
Yes. Until you file a appropriate memo, your name will be written.
But it is recorded as a change of account was filed by shown.
Yes. What you?
I am for criminal MP number 43039.
Yes.
Venkatesh, petitioner Venkatesh. My humble submission is, since the order passed by this honorable court in criminal OP 2336 of 2020-24 is clear. Yes. I explain.
Yes.
It is violating Article 141, which is ultra virus,
Yes.
which is clearly per incurium with 3 binding precedent of the honorable Supreme Court.
Yes. Where the Supreme Court directed.
Yes, my lord. Yes, my lord. Kindly see the page number.
Yes. Where the Supreme Court stated.
My lord, the first precedent is.
Otherwise, I think each and every word.
I have, my lord, I am legally submit. My humble submission is, yes, my lord. Yes, my lord. The first precedent is, my lord,
Yes.
Honorable Supreme Court in Abdul Rahman Antule, A.R. Antule case
Yes.
in 1991,
Yes.
page number 7. In my typeset contained
Yes.
page number 153. Pen note page number at 8, page number 8. Para number 5 from the bottom.
I think the last occurrence
Page-
Mr. Anand pointed out the judgment.
Totally
Yes.
contained page number 153. Number 7, para number 5. Typeset in page 7, pen note, para number 5 from the bottom. It is not possible to lay down any time schedule for conclusion of criminal proceedings. The nature of offense, the number of accused, the number of witnesses, the workload in the particular court,
Yes.
means of communication and several other circumstances have to be kept in mind. Some offenses by their very nature, example, conspiracy cases, cases of misappropriation, embezzlement, fraud, forgery, sedition, so on, so. You come to the next para B. In some places, frequent strikes by members of bar interfere with the work schedules. Thus, it is not possible in the very nature of things and present day circumstances to draw a time limit beyond which a criminal proceeding will not be allowed to go. Even in USA, the Supreme Court has refused to draw such a line.
We not go
No.
to the USA Supreme
No,
Court.
but the discussion.
We are not in USA.
No, my lord. But
What are relevant to-
but I am not saying, my lord. The Supreme Court says.
Yes, Supreme Court says that that is for the Supreme Court, not for the.
Yes, my lord. You come to the operation portion. You come to the operation portion.
Yes, where is it?
Last para D.
Yes.
This is the head notes. This is also the
But no, the Supreme Court has not directed, not. But not to, on its own facts. Hence, it is neither advisable
But
nor
I-
feasible to draw.
I have
or
been,
prescribe.
yes, but I have been delayed by three precedents.
This is
The first precedent has been declared by the Honorable.
mandatory. Yes.
The first and foremost,
You can
the law,
argue, but at the same time, you have to mind your words.
no issues,
Yes,
my lord.
otherwise,
I have been delayed by legally. I fight with my legal grounds.
yes, it
Yes.
is so, yes.
Last para, last para.
It does not mean that you can say anything.
No,
Yes,
hence it is neither advisable
yes.
nor feasible to do verdict by the UCC3. For the law related to the outer time limit and the speedy disposal has been declared by the Honorable Supreme Court in A.R. Andale case. Thereafter, some other,
Not mean that the power of the court cannot be curtailed, has not been curtailed.
Le-
In appropriate cases, in all cases, not necessary.
your perception is slightly different from the perception of the Honorable Supreme Court.
Advice in
Yes.
nature. Yes, we can argue the matter.
Yes.
Yes, argue the matter. Yes,
Let me submit, my lord.
yes,
My lord, after the A.R. Andale case,
yes.
some of the smaller benches of the Honorable Supreme Court fixed the outer time limit to be concluded criminal proceedings,
Yes.
which is brought to the notice of the Honorable Supreme Court larger bench, which comprising 7 judges of the Honorable Supreme Court in Ramachandra Rao versus State of Karnataka,
Yes.
wherein the Honorable Supreme Court decently reproaching the smaller benches of the Honorable Supreme Court as well as
Yes.
fixing outer time limit is nature of judicial legislature. Therefore, it is unconstitutional. This is the law declared by the Honorable Supreme Court in Ramachandra Rao case.
Yes, very, very.
Yes,
Where is the particular,
Yes, first I go to the head notes, my lord.
Not head notes, but straight away come to the point.
Illa,
Head note is the particular author took the particular portion.
Okay,
So, which is the
yes, my lord. Sorry.
appropriate paragraph in the main judgment.
Come to the page, kindly come to the page number 64.
Yes,
Once again, the A.R. Andale case has been reiterated by the Honorable Supreme Court in Ramachandra case.
64.
Yes, page number 64.
Which para?
Para number 1.1 from the bottom.
Yes,
Lord, wherein the Honorable Supreme Court clearly enunciated the outer time limit fixed in the Deoraj Sharma case, as well as the common cause cases also per incuriam, because which is violating the Article 141, which is the violating the doctrine of precedent declared in the A.R. Andale case.
Direct case we discussed.
Yes. Para number 1.1.
Yes.
It is neither advisable or feasible nor judicially permissible to draw or prescribe an outer time limit for conclusion of all criminal
All
proceedings.
criminal proceedings.
Yes, my lord.
That was the mind.
Yes.
All for
My case is not an appropriate
That's
cases.
why this court told you, mind your words before saying anything. That's why we not
Proceedings.
in any criminal proceedings.
Yes,
Yes.
which means all criminal proceedings, my lord.
Limit for conclusion for all criminal proceedings.
The-
Not permissible to draw
I continue.
an outer limit.
May I continue?
conclusion for all the criminal proceedings. Yes.
The time limits are bars of limitation. My lord, kindly visualize.
Yes.
The time limits are bars of limitation prescribed in the several directions made in the common cause, Rajrio Sharma and Rajrio Sharma could not have been so prescribed
Yes.
or drawn or good law or
Or
not good law.
Yes.
Yes, the criminal courts are not obliged to terminate trial or criminal proceedings merely on account of lapse of time.
Yes.
This is my case.
Yes.
This court has fixed out 3 months outer time limit to be concluded the criminal trial.
Yes. Yes.
Yes,
Anybody can interpret on their own.
my lord. Next page number 65, para number 1.4. The dictum in A.R. Andale case is correct and holds the field.
You are also no quarrel in that aspect. Yes. That it does not mean in all the cases, in any case, the court can.
But my case is
yes.
not appropriate circumstances. It is a premature stage, my lord. Therefore, that is my case.
Yes.
This is a premature stage.
Yes.
Page number 66, para number 2.
Yes.
The criminal courts should exercise their available powers, such as those under section 309, 311, and 258 of the Code of Criminal Procedure, to effectuate the right to speedy trial.
Yes.
A watchful and diligent trial judge can prove to be better protector of such right than any guidelines. In appropriate cases, jurisdiction of High Court under Section 482 CRPC and Article 226 and 227 Constitution can be invoked.
Please.
Seeking,
read again.
yes,
Please
yes,
read again.
I come to
Please
this,
read again.
yes,
Yes. In
My lord.
appropriate cases.
my case
Please
is,
read again.
yes. In appropriate cases, jurisdiction of High Court under Section 482 CRPC and Article 226 and 227 Constitution can be invoked seeking appropriate relief or suitable directions.
That-
My lord, my case is not appropriate case. In these circumstances, it's a premature stage. My lord, as per the intention of the Honorable Supreme,
that Article 142 is violated.
yes,
In appropriate cases, this
Yes.
court can invoke 482.
yes,
So this court now has to see whether it is appropriate or not.
yes,
Yes,
yes.
but it does not mean that in no case the court has to.
No, I am not complete, my lord, complete. Come to the operative portions, please.
Yes, that is sufficient. That is sufficient.
My lord,
That is sufficient. In appropriate cases, the court can pass orders.
no, my lord, my case is not appropriate circumstances. This is a premature stage. Not only,
Point on your case, not on the judgment. Judgment is very clear.
my lord,
Appropriate case can.
this is discussion. I am come to the operative portion, please.
Yes, sir, yes, sir. What is the case in your case?
Kindly come to the 1 minute, visualize the operative portion.
You need not go into that, already settled. Yes. In appropriate cases, this court can. If so.
No, my lord, no, no, my lord. This is the, my particular point, my lord.
Yes.
Page number 89.
No, sir. Yes.
I read, my lord,
Why, sir? Yeah, already you
Yes.
read the appropriate portion.
my lord, only 3 lines. Thirdly, we are deleting the bars of limitation on the
Yes.
10 grounds
Yes, who is
that it amounts to judicial legislation.
approved for the another. Yes, you can. Yes, if you want to.
My lord, very
on the facts, I will hear.
Yes.
Already law settled. Yes,
What-
we also brought to the knowledge of the court. by-
Yes, my lord.
judgment.
Only one recent observation of the Honorable Supreme Court. Only one reason.
Yes, you can come to the factual point.
Very recent directions of my Honorable
Yes,
Supreme
yes.
Court, my lord.
Yes. You can come to the legal, come to the factual aspect, and if you want further arguments, you can file in the form of written arguments.
My lord, only one direction, very recent directions of the Honorable
Yes, sir,
Supreme Court.
I'm not in a position to hear you now, because you can file already, you consumed so much of time.
இல்ல, இந்த directionல தான் வந்து இப்ப ரீசெண்டா எல்லா ஹைகோர்ட் ரெஜிஸ்ட்ராருக்கும் வந்து டைரக்ஷன் கொடுத்திருக்காங்க.
We also received. We
Yes.
also, that's why this court said. Yes, that's why this court said. We received it 3 times.
My lord, your judicial concerns must be satisfied whether it is
That's
appropriate
why-
circumstances or not
Yes,
circumstances.
that's why there is
Yes.
no bar. There is no entire bar. There's no bar. But in appropriate cases, the court can use the power. If so, you have to demonstrate before this court what is your factual act.
My lord,
Yes.
as per the intention of the Honorable Supreme Court and the core dictum and the ratio decision of the Honorable Supreme Court in 3 precedents
So,
are very
you
clear.
have to
The
demonstrate
prolonged,
before this
yes,
court
my lord, prolonged
Actual
incarceration,
what way this case is,
The-
comes under the court cannot grant any time.
my lord, as per the intention of the Supreme Court is the appropriate circumstances is the prolonged incarceration without trial. Detained in the prison, it is the appropriate circumstances. Another circumstances is either the victim or,
That is for the particular case, not for all cases.
my lord, appropriate circumstances is
Yes.
as per the intention of the Honorable Supreme Court.
Varied case to case. That's why the Supreme Court said it.
My lord,
So. you can-
so
cannot-
far as I am concerned, this is not
you can-
appropriate
I'm not
cases.
before
I'm
the court
legally
on
say,
the actual aspect.
Well, in
What
this
way
case-
is possible to you?
in this case, 1 month, 1 month direction given to the, to be committal the case. This is not appropriate circumstances, premature stage.
That was.
In all cases, my lord,
That already time lapsed. They one month time lapsed, the 3 months time also lapsed.
yes, I come to your point, my lord. Each and every 3 months ending, the,
After 1 year, the case is going on.
my lord, after 3 months,
So
my
I
lord,
think what way your right is affected?
yes, my lord,
That order was already lapsed, time was lapsed.
not left, my lord, extended by the,
That is different.
yes,
First, the order is to commit within 1 month. That was over. Thereafter, 3 months, within 3 months, trial has to be completed. That was also over. Trial has not been completed. Then what way you are right?
but only one direction have been decided me as a from the ab initio stage, I have been treated as a convicted felon by the trial court.
That-
Whenever I am filing any,
you can take action as a, for that, particular-
that is different, but
Yes.
showing only one reason, the trial court showing only one reason, outer time limit 3 months. All, whenever, my lord, you,
Without
this-
going, one second, without going into merits of the case, that order time was already lapsed, so your trial itself has become infructuous.
no, my lord, the time is extended.
Yes.
Therefore, I'm,
Become infructuous. So, if tomorrow you can say before the same court, whatever the arguments advanced before this court, that the judgment is clear in curiam. So that therefore, I'm not, I don't want to obey the judgment. So I'm not able to conduct the case in a speedy manner. So like that, you can approach the trial court.
when I am filing further investigation related by Haribai Vinubai Malaviya case, the accused can seek further investigation. The magistrate court disposed.
The same argument can be argued before the trial court, so that they are liable to take all.
No, my lord, the magistrate court says
Because
the outer time limit 1 month given. Therefore, I
that
cannot.
was not considered. That was lapsed already. They would. Yes.
Last adjournment filed a 309 CRPC petition,
So,
but court says 3 months outer time limit.
yes. whatever-
Therefore, that is my difficult.
Already the 3 months time was over. What is the second time?
But the trial court still says 3 months outer time limit, saying,
That was not considered. They cannot be considered by this court because this court directed to complete 3 months. The trial court has
my humble
not
submission,
completed. So,
my lord, after some roster, some honorable judges are extending the time from 3 months to, yes, last, my lord, I am not getting that order, but extended.
Wait, up to which date? Up to which date?
The தீபாவளிக்கு 2 நாளைக்கு முன்னாடி எக்ஸ்டெண்ட் பண்ணாங்க மேல,
Diwali.
இந்த லாஸ்ட் தீபாவளிக்கு அப்புறமா வந்து திரும்பியும் இப்போ வந்து பிபி பப்ளிக் ப்ராசிக்யூட்டர் வந்து லெட்டர் ஏதோ என்க்ளோஸ் பண்ணதா சொல்றாங்க.
அதுவும் முடிஞ்சது இல்ல.
My lord,
அதுவும் முடிஞ்சது இல்ல. டைம் முடிஞ்சது இல்ல.
முடிஞ்சிருச்சு. பட் இப்போ வந்து ட்ரையல் ஜட்ஜி வந்து பிபி வந்து நீங்க லெட்டர்,
அதுக்கு நீங்க தனியா நடவடிக்கை எடுங்க சார். ஏன் இதுல
பட் திஸ் போர்ட்ஃபோலியோ எக்ஸ்டெண்ட் த டைம். My lord,
எக்ஸ்டெண்ட் பண்ணவே இல்ல. எங்க இருக்கு? எங்க எக்ஸ்டெண்ட் பண்ணிருக்கு?
இல்ல நீங்க பண்ணலாம். My lord,
இல்ல
but
யார் பண்ணாலும்
after some portfolio,
put only 1%. Up to which date the can you say?
my final humble submission is, my lord, this court is not only for victim. This court is our fundamental of our constitutional biofocus interest of justice is our
Yes.
fundamental premise.
But at the same
How
time,
extend the victim rights is protected and enshrined in the constitutional.
the way of attitude also has control. Way of approach and the attitude.
But false averments in the petition filed in criminal OP.
So-
They are stated so many false averments which are attracting the CRPC 303,
You
340
can take action.
perjury.
You can take action.
What action has, my lord? Therefore, we filed the
You
recall
are
petition.
the advocate, you know very well.
Yes, my lord.
Type of,
This court is-
action has to be
This
taken.
honorable court is an ample power to take action in the 340 CRPC perjury. They have made several averments, false averments, misleading this honorable, deceiving this honorable court.
Not in the same direction. Yes.
Lord, meanwhile, my fundamental rights may be ensured in coming,
Yes. At the same time,
whenever I am filing the miscellaneous petition in seeking some,
so your remedies elsewhere, not through this application. Not through this application.
while
Not through this
disposing,
application.
my criminal MP, you may direct some to ensure my fundamental rights in miscellaneous
What
application.
type of fundamental-
When I'm filing this petition,
Is it
which
not
is,
your duty to challenge that order without any material, barely because your arguments, how can this court come to conclusion that all the petitions were dismissed?
if you call the all,
even-
if you call all the records, you can see
This is-
how many petitions are pending in the trial court.
Without challenging those orders, it is not the duty of this court to see all the things. If anything, this before this court, by challenging the orders, then this court can consider. Otherwise, how can we? Yes.
Pleasure.
Yes.
Criminal MP, SR number 4303. Identity, I filed the contest. SR number 4303. 303.
You have the copy? Yes.
Actually, have a look at vacancies.
Yes.
One way, if I put order, you check on the trail. You'll actually have a just look at, and you take only 5 minutes.
Yes.
The employer was registered on 88%. But they haven't taken.
Yes.
The dealer did everything alone.
Yes, yes, please. Yes. What is stage of the case now?
Even PW owners are not examined.
3, PW 1, 2, 3 has been examined today.
Today exam.
Yes, yes, my lord. Chief also. This kind of false averments are again and again made by my learned friend.
That's right. That is.
I can demonstrate that by simple facts. We both my university and today. Is the requirement. The mathematical graduation. And why it is of course it is all over the board and maybe the art of speed is which is a short span of like 7 1 is 725. Yes, she can. The constitutional court has also power. She not only approached the court, but speedy disposition. The approach, she has come to literally in all the verifications, in level verifications. In all recipes, in my experience, I have not seen any individual petitions in recipes. 8% of in all matters, she filed that individual petition HCPs. The division match petition saying that this is a matter and we will take care of it. Then the application seeking further investigation and I can speak. Even though she has a right, the financial viability of the lady is highly questionable. And that I will answer.
We need not go into the aspect. Yes, because yes, we need not go to the financial position of the defendant complainant that we but
police is backing
can you demonstrate what way the speedy trial affects you? That is one thing. Second thing, according to me, that order itself has not been compliant. Yes, already time lapsed. Time lapsed. So you know the order cannot be set aside or recalled because already lapsed. If any application filed for extension of time, then you can approach this court by objecting that extension of time. Yes, that is according to me, in my view, it is appropriate, but it does not mean that the entire order has to be set aside. Once that time was already lapsed, it was I think become infructuous unless it is extended. Now it has not been extended.
Only one observation, my lord. If you while you are dismissing or some other decision made in our criminal MP, you kindly mention the that order has been not extended and the infructuous. Maybe mention the.
You came to conclusion that the name of dismissing the application.
Whenever in the trial court insisting the 3 months outer time, even after infructuous, even after the lapse, we have been refuted our fundamental rights.
Please understand one thing. Have any objection, any grievance, you have to challenge that order. Without challenge, if this person is challenging that order, then this court can go into that aspect. Yes, only because of this petition, the judge passed the order.
My humble submission, whatever you are pronounced.
Can you challenge any one of that order?
Yes, we have challenged many orders. We have gone to SLP.
When those orders were challenged?
Well, criminal RC, two criminal RC.
When?
But not in typeset. Further investigation நாங்க seek பண்ணுதோம்.
That is further investigation எப்ப வரும்?
இல்ல கேட்டோம், அது தரல. நாங்க SLP போறோம். SLP ல வந்து அப்படி
further investigation நீங்க கேட்கவே முடியாது.
இல்ல ஹரிபாய் வினுபாய் மாளவியா கேஸ் படி.
Second thing, when those petitions were returned, order passed. After filing of this petition or before this?
Before filing after filing one petition in name Deva Kannan. The time is extended. நான் SLP வரும்போது நான் சுப்ரீம் கோர்ட்ல இருந்த மேல senior vehemently argued the case. One of the presiding judge says, you go to the very same judge, you argue the three precedent before the very same judge one who passed the order. Therefore some thought they have.
Yes. So understand.
Arjun is one of them. Has been recurrently brought by the police on the very same day, while he was in his farm, not at the length of that, but the farm.
Yes, sir.
His leg was broken.
That is different.
What is the motive behind by who instigated it?
We are not going to that because we are not going to hear the case and decide the case. Now, legally, whether this court has power to order pass of speedy trial or not, that is one thing. Yes, there is no bar, there is no any complete bar. That is one thing. Second thing, what may causing prejudice to you? That is second thing. Third thing, the order itself is not in force as on date. So, in this point only I have to answer. Yes.
The order of extinction will always be imposed, even if it's not for 5 years. Because when the Allahabad Bar Association made appeal to the Supreme Court, an automatic vacation of stay, the automatic vacation of stay order.
That is different.
Supreme Court says that once stay is granted, it will be
That is different because that order is in order and that is outcome of the result of the main order. That's why there's a difference. This is main order already disposed of.
Disposed of, but
Yes.
the time board fixed with the Sana report is still that while check is still under duty to apply the order.
That was already thereafter I think one year lapsed, I think. 1 year, 2 years.
Whether it will be
One year lapsed.
whether time may be lapsed or not is not the question. But once the order is passed, he is bound to follow even after 2 years. After 2
Yes.
years, he has to, at least if it is not completed within 3 months, he has to at least complete it within 2 years or 3 years.
That's why that order no way affects your rights. It shows because after now we are after 1 year. Sir, discharge ஆமா டிஸ்சார்ஜ் போட்டா மெட்டீரியல் இல்லைன்னா டிஸ்சார்ஜ்.
இல்ல ஒரே நாள்.
சோ உங்களை பொறுத்த வரைக்கும் என்ன பெட்டிஷன் போட்டாலும் லாயர் கோர்ட்ல வந்து ஜட்ஜஸ் வந்து அட்மிட் பண்ணணும். உங்களுக்கு எகென்ஸ்டா ஒரு ஆர்டர் போட்டாங்கன்னா அப்ப உங்களுக்கு அது எகென்ஸ்டா இருக்கும்.
இல்ல அப்படி சொல்ல.
So even assuming that the order is wrong order, what's the remedy? You have to challenge that order in the manner known to
But
law.
only one thing, my lord,
Yes.
very serious. This is deceiving this honorable court is very serious. They have several false affirmations against me.
So you can take action.
They are projecting himself as a disease is a followers of Mahatma Gandhi.
No. This
Projecting
is
him.
not relevant.
Yes, I'm a law abiding citizen.
False affirmance and false affidavit. You can approach this court by way of appropriate remedy.
எங்களுக்கு என்ன our humble submission என்ன my lord? Notorious matter. This is a notorious having split of FIR more than 307 rape cases, POCSO cases, various enmity. நாங்க ஒவ்வொரு கோர்ட்லயும் வந்து CA கலெக்ட் பண்ணிட்டு இருக்கோம் டிஃபென்ஸ்க்கு. எல்லா கோர்ட்லயும் certain grounds வந்து CA வந்து refuse.
That is different. So you can
My lord, 3 months outer time limit.
you can approach this court for extension of time or any other manner, but you cannot. You are attacking the order itself by
This 3 months.
by using the
But the 3 months outer time limit taking advantage of petitioner, my lord. Always saying 3 months outer time limit, 3 months outer time limit before every court.
Yes. Will pass on.
Humble submission, final humble submission, my lord. Kindly mention the lapse of time, my lord, please.
14 March. Orders 14 March.
Kindly mention the lapse of time.
Which case?
Devakanam, for Devakanam, petitioner
Already
Devakanam.
filed or not?
Already have a change of
No,
account.
no, no. No, sir. Had you circulated the memo,
Memo not yet.
then will you
Before 14/3, my lord.
you can circulate, you can circulate. Yes.
My lord, my petition may be given number, my lord. In filing number la irukkenno. May be given number. மத்த petitions number கொடுத்துட்டாங்க எனக்கு கொடுக்கல.
Maintainability இருக்கா?
Yes.
Maintainability இருக்கா? அது request. Petition allowed.
Another one SLP. So pledge.
Number. Yes, sir. So we'll post, formally post on next week. The only your petition number. So we'll formally post on next week.
My lord,
And thereafter we'll pass orders.
in the event of any SLP, we have to move. Therefore, I am seeking number. Otherwise,
SLP,
in the event of aggrieved by any order of this honorable court, I have to move another one SLP. Therefore,
it is for you to decide.
yes, yes.
But already-
Therefore, I am seeking number.
No, but already this court numbered
Yes,
for other petition.
yes, yes,
So the same yardstick has to be applied for you also.
yes.
Yes. Yes, sir.
Yes.
Yes, sir. For one of the petition, I think already got, this court passed an order.
Two petition given number, one petition is not given number. One remaining in filing number. Accused name is Venkatesh. Petition number is Venkatesh. Filing number is 43039. Criminal MP.
Yes, yes. We'll pass.
Much obliged. Much obliged.
Give number to the,
Much obliged.
maintainability.
Much obliged.
Number.
My arguments may be considered for final
Number.
main petition.
Section on the. 7. We'll post on 7 formally.
Much
Because
obliged.
the petition has not been so far numbered, your petition. Other
Yes.
two petitions number.
Yes, my lord.
Yes.
Verification side number 83, Surya Narayanan.
May I please, ma'am. Challenging the order of the
Entered at business.
first responder. It's on the ground.
Yeah, we'll adjourn some other dates.
That's
5 o'clock.
already I argued this matter, not sir.
What distance?
Yes, not. This temple celebration issue. 5 Karais plots, there
Yes,
is
yes.
not only the,
Draft order for
only, only for the other side.
next Karaida.
Yes.
Sorry, the
So
5 Karais.
second Karaida, you belong to second Karaida.
Yes. But here not, sir, already there is the order of this honor court not. Lordship kindly see the repetion order at page number
Today,
38.
most of our response documents.
Yes,
Yes.
I am for the third respondent, my lord.
Yes.
I am not a party.